Calling our next case, Hilyard versus Johnston. Good afternoon. This is a 15-minute argument. Mr. Hilyard, you can begin when you're ready.
Thank you. Good afternoon, Justice. It's a privilege and honor to be in front of you again, and Justice Bolden for the first time. This case is pretty straightforward. It's a matter of interstate child support, which has been a problem for over 75 years. Since the 50s, legislation has been tried to be passed to make it uniform. The issue that has led up to my argument today is child support and family law matters are the exercise of personal jurisdiction, are analyzed under a test that are more narrowly tailored to business, corporate type transactions or parties, not family law. To remedy the problem in 2008, the Uniform Interstate Family Child Support Act was revised for the third time. And as of 2015, all 50 states have enacted it. Michigan enacted it in 2015, and it became effective January 1st of 2016. The importance of that version being enacted in all 50 states is it includes its own expanded long-arm statute that allows courts to exercise personal jurisdiction in as broad as constitutionally permitted. What that means is the traditional two-step analysis is narrowed down to one, like a constitutional analysis. In the case prior, there was a lot of talk about what did the legislation do, what did the legislature say. This court, in Green versus Wilson in 1997, held that Michigan's long-arm statute requires that two-step traditional process. And important to note, in that decision, it also said, and I'm paraphrasing, that if the legislature wanted to, it could have written language into the statutes that confer jurisdiction to the broadest limits of due process, as other states have done, but chose not to. Here we are, 25, 26 years removed from Green. In 2016, Michigan's legislature did just that by enacting the 2008 version of the Uniform Act. That expanded long-arm statute now allows for the exercise of jurisdiction to the broadest sense constitutionally possible. And so under that expanded long-arm statute, we have to only ask ourselves, did a non-resident purposely avail himself to the forum state, to Michigan? And the answer to that is yes. If the court was to look at Appendix I, it's a letter from the appellee to the appellant dated November 14th of 2019. In that letter, subsequently a day after the youngest child turned 18, it was penned on the advice of counsel, and the appellee specifically states, any legal action would need to be filed within Ingham County, Michigan, not Cattaraugus County, New York, where the judgment of divorce and the child support orders were. That language in and of itself is clear that he anticipates foreseeing his action of failing to pay child support and terminating the court order direct deposit where child support was paid was going to get him held in to Michigan and have to answer for that. This cause must arise from activities in the state. Since August of 2010, when the appellant and the children moved from New York to Michigan, all of the appellee's parenting time was done here in Michigan. The last time was in June of 2019 when he attended the children's high school graduation. The activity, the payment of child support, was done through court-ordered direct deposit, received by appellant in Michigan. In 2016, the appellee attempted to register the party's judgment of divorce for purposes of trying to prohibit the appellant from taking the children to Mexico on vacation. Subsequently, the trial court said this is frivolous. That judgment of divorce, with those child support provisions in there being registered, that breach, this failure to pay, was an act that happened, caused in Michigan. And the last part of this test is there a substantial connection to Michigan? And the children have been Michigan residents since 2010. No other state, no other jurisdiction, the children cannot be supported in any other jurisdiction. The U.S.
Counsel,
Supreme...
I want to just jump in. I understand all your argument about the connections to Michigan and why there should be jurisdiction. But if we were to agree with the Court of Appeals and just disagree with you on those facts, how would this case move forward? Like, just as a practical matter, how does it work?
So if the court were to agree and remand this back, because the Uniform Act says the issuing order, the state who issued the order, there's only one state, so this is the controlling order.
New York.
Correct,
Right.
New York. The trial court would have to make a determination, based just on this case alone, whether or not the appellee terminated the direct deposit and failed to pay. That would trigger an automatic provision in those orders that would have increased the child support from December of 2019 until each of the children turned 18. One would have been January 8th of 22, the other one November 13th of 22. Those arrears would be fixed. Interest at the rate of 9% would be added because the statute says in 2604, it says the issuing state's order is the controlling order and it governs terms, duration, interest, and collection of arrears. So if this were to be sent back down to the trial court, those figures and determinations would have to be made, and it's very simple. And then the trial court would have to enter its order. It would be registered and submitted to Missouri, where the appellee is a resident, and then the general collection process, Michigan's general collection process, would then take over to collect those arrears.
So why are we here? I'm just like, there's a pathway for collecting in this case. Is that correct?
Well, we're here, the biggest issue we're here is because the appellee never appeared. He never responded to the registration.
Right, so I understand there's like an enforcement issue, and I understand that.
And it was the friend of the court or the court itself, without the party bringing up the issue of personal jurisdiction. The court itself, sua sponte, decided we have no jurisdiction, which can't be done. It's an affirmative defense. It's personal to the party, not to the court, unlike subject matter jurisdiction where the court or the parties can bring it up at any time. The way the Uniform Act is written under that Article 2 that discusses registration, it is very specific. Personal jurisdiction is not required to register, which the trial court said it was. As soon as it's registered and the trial court enters its order confirming the registration, the appellee was essentially waived any defense he may have had to be able to argue, including personal jurisdiction, after those 20 days transpired. So the biggest issue here is the trial court failed to recognize that enforcement is automatic and in jurisdiction is not an issue. Whereas opposed to if this was a modification, when a petition requesting modification, like in the Kulko case, that was a case for modification, and they said all of the contacts that they alleged there were insufficient. Here, this is enforcement. It's automatically able to be enforced. But the trial court didn't agree with that argument. And then the Court of Appeals, in its opinion at asterisk page 4, on the age issue, the Court of Appeals had stated something to the effect that failure to pay child support until the kids are 21 is insufficient to be able to exercise jurisdiction, because at the time the appellee stopped paying or failed to pay, they were 18. That's true. But what the Court of Appeals failed to recognize is that Section 204 of the Uniform Law that says New York's order controls, and under the New York Family Court Act, a parent's duty, a parent's obligation to support his or her children is until the age of 21.
So I guess I'm trying to, what I'm grappling with is, I understand your arguments. What I'm wondering is, you know, we obviously look at cases that aren't just error correcting or, you know, cases that impact one party, but, you know, are more about the system as a whole. And I'm trying to figure out what about this case is critical for the state of Michigan. And what I'm wondering is people move all the time during divorces and they end up in different states than where the original judgment is. That happens obviously all the time. It's why we have these statutes. I'm just wondering, is this just, why haven't we heard about this before? Is this a huge problem, or is this a unique case that because the facts are different for some reason, it has to use a different pathway than those cases?
Well, this is a huge case. It has the potential to be a huge case. Because it's a uniform law, this court's decision is going to either, you know, help or hurt.
But does it dramatically change how family law practitioners will practice? I'm just wondering, what are people doing now versus what would change?
In the area of interstate child support, yes. Because in Hillsdale, which was decided in the late 90s, that court had the opportunity to decide whether or not failure to pay child support was sufficient to be seen as a tort that caused harm in the state. Those, and then Poindexter versus Willis and Black versus Rysdale, all of those had said failure to pay child support is sufficient to exercise jurisdiction under that effects test. The problem is those cases that came before this one 30 years ago, they were paternity matters. So the duty to support did not attach because paternity had not been established. There's no cases in Michigan that say if paternity is established, there's that automatic statutory duty to support, and so therefore, failure to pay based on a statutory duty is a tort that is done or causes an effect in Michigan. Here it has. The parties were married, there's no dispute about paternity. The child support that's paid was used for the children's well-being here in Michigan. Doctors, clothing, food. And just because the appellee chose not to pay, it does not mean that the children's needs ended. They didn't. That all fell on the other parent. And that happens all over the place. As Your Honor said, we're a moving society now. Without something in this state.
But is that her only way to get enforcement? Are there other, by the court saying, nope, we don't have jurisdiction?
This is the only one.
Okay, because I'm wondering, is that the answer?
It is. This was addressed in New York as well. I was admitted pro hoc vice, and they made.
So has everybody just said, we no longer can work on this case?
We can no longer do this.
Okay. That's what I'm trying to figure out.
Right, yes. Sorry.
Okay.
Long way around.
Yeah, no, that's okay. Now, I'm just trying to figure out, like,
Yeah.
what is the remedy, and is this the only way for her to seek her remedy?
This is the only remedy, because every other state that could have had jurisdiction has said, no, you are not a New York resident, you're not a New York resident, go back to Michigan.
Okay, thank you.
Thank you. If there's any other questions, I think I would rest on my brief.
Okay. Thank you very much.
Thank you, Justices.
Thank you.
The case will be submitted.